I'm Ernest Wolfie Daniels, and this is my presentation on the two landmark cases, the New York Times versus Sullivan and Gertz versus Welch. In March of 1960, the New York Times published a full-page advertisement for a group that called themselves the Committee to Defend Martin Luther King and the Struggle for Freedom in the South. The group's intent was to raise money for the legal defense of King, including a recent perjury charge. The advertisement's title was Heed Their Rising Voices, and contained several falsehoods and accusations that named L.B. Sullivan indirectly. The group published the names of the members of the committee, who proved to be 4 Alabama clergymen. Sullivan's duties in his role as Commissioner of Public Affairs included supervision of the police department. American history teaches us that civil unrest was running high at this time, and political figures were under heavy fire from equal rights demonstrators. Sullivan filed a defamation lawsuit against the 4 clergymen and the New York Times because Sullivan felt that the 3rd and 6th paragraphs of the advertisement held defamatory content. The New York Times advertisement alleged that the leaders of the student group were expelled because they sang "My Country 'Tis of Thee" on the Capitol steps, and that truckloads of police armed with shotguns and tear gas ringed the college. It also made the claim that the entire student body protested the actions of the state authorities and had their dining hall padlocked by the police in an attempt to starve them into submission. The 6th paragraph accused the Southern violators of answering Dr. King's peaceful protests with both intimidation and violence, and that they bombed Dr. King's home and almost killed his wife and child. They assaulted and arrested King 7 times for speeding, loitering, and/or similar offenses, leading up to the final charge of perjury, a charge that holds the potential of 10 years of imprisonment. In his capacity as the Montgomery commissioner, he claimed that the they referred to in the accusation clearly identified him as the target. The 6th paragraph talks about the people who did the arresting as being the Southern violators. In this case, it is accusing the Montgomery police of answering Dr. King's protests with intimidation, increasing violence, bombing his home, assaulting his person, and charging Dr. King with perjury. The implication here was that he either ordered the actions or condoned them, or both. Sullivan had a difficult criteria to prove to claim his defamation. In order to claim defamation, the following criteria had to be met. There has to have been a defamatory statement made either orally or in writing. The defamation must have been published. In other words, it must have been made to or seen by at least one person in addition to the writer. The plaintiff must see or hear the statement or material too. In this instance, it is also a liability for the publisher, the New York Times, for publishing the defamatory advertisement and distributing it to its subscribers. In order to prosecute, Sullivan had to prove falsity. Falsity being that the statement or article must be provably false. It cannot be an opinion or a statement that is unable to be proven true or false, but rather something that is quantitative or demonstratively able to be proven one way or the other. It must also prove false. For this criteria, the requirement of proof is subject to the individual's position as it relates to the topic. It has to fall within one of the following 4 categories. First is a public official. Public officials have to prove that the person published the statement with actual malice. He or she must have either known the statement was false or that they recklessly disregarded the truth and published the statement anyway. In this instance, malice must be proven. The second is an all-purpose public figure. An all-purpose public figure has the power to influence society and has obtained notoriety or fame. They readily have access to media to refute any allegations against them. The third is a limited purpose public person. A limited purpose public person is someone who has thrust himself or herself into political controversy. This person is categorized as a public figure as it relates to the specific issue or topic they have chosen to become synonymous with. They have to prove that the statement was made with actual malice, the same as with a public figure. Private person. A private person is anyone that doesn't fit into any one of these prior three categories. The state determines the level of liability involved and renders judgment. He must also show identification. To meet this criteria, the plaintiff must be able to prove that the statement was made about the plaintiff. The plaintiff doesn't actually have to be specifically named, but by the process of facts can be identified as the person spoken or written of. He must demonstrate, unless considered defamation per se, injury. The statement or article must be proven to have impacted the reputation of the plaintiff where it has caused him or her to be thought less of by other people or shunned by other people. It may have been indicated that he or she had a communicable disease or caused him or her impairment or hindrance of their ability to obtain or retain a job. The judge may grant special emphasis if the statement had to do with work ethics or professionalism. Even though the state awarded Sullivan $500,000, the U.S. Supreme Court overturned the ruling. The reason for this was that they determined that Sullivan, acting in the capacity of a public official, is subject to public scrutiny. His burden of proof then requires actual malice. Because the state judge did not require proof of actual malice, it was deemed absent. The Supreme Court also determined that the 14th Amendment, that prohibits the state from violating the First Amendment's freedom of press rules. The First Amendment holds publications exempt from liable unless malice or reckless disregard can be proven. The U.S. Supreme Court determined that since there was no malice or reckless disregard, and that as publication in the New York Times was exempt from liable, they reversed and remanded the decision. In the Gertz versus Welch case, the Supreme Court further defines and sets precedents for what determines whether a person is a public official or a private citizen. In this case, the Nelson family, whose child was the victim of a police shooting, hired Elmer Gertz to sue Officer Richard Nuccio for civil damages. Nuccio, convicted of a second-degree murder, had shot their son. During this era, relations between the Soviet Union and the United States were almost non-existent. The atmosphere and sentiments of the public towards communists and communism were extremely negative. When Robert Welch, the publisher of American Opinion magazine, commissioned an article from someone he deemed a reliable source, and failed to proofread the article before running it, he found himself facing a lawsuit. Gertz filed a lawsuit against Welch because of the many slanderous remarks contained in the commissioned article Frame Up, Richard Nuccio and the War on the Police. The article contained accusations that Gertz was the architect of a frame-up of Officer Nuccio. It stated that he was both a Leninist and a communist fronter. It also stated that Gertz was an officer of the National Lawyers Guild, described as a communist organization that probably did more than any other court or any other outfit to plan the communist attack on the Chicago police during the 1968 Democratic Convention. Other defamation also occurred when it stated that Gertz had a criminal record and had been an official of the Marxist League for Industrial Democracy, originally known as the Intercollegiate Socialist Society, which has advocated the violent seizure of our government. When the defense tried to label Gertz as a public figure, the Illinois courts initially deemed it inaccurate. Gertz had neither involvement in nor media coverage for the criminal prosecution of Nuccio. Quite the opposite, Gertz avoided publicity and only attended the court hearings of Nuccio to file the damage case for the family. The Illinois courts awarded Gertz $50,000 before changing its mind and stating that the New York Times set a different precedence. The U.S. Supreme Court awarded Gertz $400,000 and overturned the ruling. Because of the public sentiment towards anything communist related, accusations of communist activity or sympathy levied against Gertz was extremely damaging to his reputation. As an attorney, he stood very little chance of being hired if he was considered a communist sympathizer. The additional accusation of having a criminal record, which was proven false, also held the potential of having him disbarred. These kinds of allegations would damage his reputation beyond all reparation. As a journalist, several things could have been done to prevent this situation from having occurred. The first and foremost would have been to check the facts. No matter how reputable you believe your source to be, you must always allow for human error and bias. To not only publish an article without checking the facts, but to then add in a blurb stating that the facts had been researched and verified is tantamount to suicide. After checking out the facts, you find inaccuracies, you need to remove them. If you can neither confirm or deny an allegation, it is better to err on the side of caution and remove the potential defamatory content. In the state of Virginia, the elements needed for a defamation case are described as the publication of an actionable statement with the requisite fault on the part of the defendant. The definition of an actionable statement is one that must be a false statement of fact that harms the plaintiff in the community or deters others from associating with him or her. To qualify for defamation per se, they must be statements that are so egregious that they will always be considered defamatory and are assumed to have harmed the plaintiff's reputation without the need to prove it. Specifically, in Virginia, any of the following things qualify for defamation per se according to digital media law. The first is that it attributes to the plaintiff the commission of some criminal offense involving moral turpitude for which the party, if the charge is true, may be indicted and punished. The second is that if it indicates that the plaintiff is infected with a contagious disease. The third attributes to the plaintiff unfitness to perform the duties of an office or employment of profit or lack of integrity in the discharge of the duties of such an office or employment, or that it hurts the plaintiff in his or her professional trade. The definition of a public and private figure are essentially the same as the Indiana laws, as are the actual charges of malice and negligence, as they relate to public officials, all-purpose public officials, and limited-purpose public officials. They must prove that the defendant acted with actual malice. The private figure may seek compensatory damages when the defamatory statement presents substantial danger to his or her reputation. In the absence of easily recognizable danger to his or her reputation, the action can still be taken if malice can be proven. While there are plenty of lessons that can be learned from these two cases, and the study of the laws in effect in my state, the major lesson is that of knowledge. For instance, while I live in the state of Virginia, my articles can be about people that are not within the same state. I live in a border town between 4 states, where state laws of defamation can become blurred. I need to be familiar with the laws of whatever state the person or company I am writing about is located in. The lines between states are further blurred by the advent of the Internet, where once a journalist might only have had to worry about his or her own state laws. Reporting can now occur across many different states. I have learned that it is better to err on the side of caution than to not have verifiable facts to back up anything that is reported. I've also learned that the identification of another person can occur by forms other than direct naming. Even without stating the person's name, the article references you can be sued and held liable for any statement or publication proven intentionally or unintentionally slanderous. I think the best question to ask yourself before publishing anything is, what would you do if the things you are writing or things you are about to say were said about you?